You are listening to the Ask the Experts show with host Steve-O. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back for our last half hour of Ask the Experts. It's been kind of nice. I'm able to sit down with our next expert. He can't do that. I can, though. Because this is such an important area, especially to our demographics. Let me introduce you to, now he's becoming a friend, attorney, Paul S. Labiner, Esquire.
Steve, good afternoon.
Wow, that just sounds like that Esquire.
Love the way you say Esquire.
Is the valet downstairs? So tell everybody, because it's so important when it comes to planning, and a lot of people sometimes wait till the last minute, or they think they can do it themselves. And you get to say, see, you can either pay me now or you'll pay me later. But he's such a good guy, and I think that's so important when it comes to sitting down with someone who does estate planning, probate, wills, which we're going to get into today. Let me introduce you again, Paul S. Labiner. Paul, tell everybody about your practice. So your office is in Boca.
My office is conveniently located.
But you cover other areas.
Oh, sure. I mean, I have clients throughout the South Florida area, from Jupiter all the way down to Miami. I'm also licensed in the states of New York and New Jersey, which is quite convenient and beneficial for many of my clients.
I hope the snowbirds heard that.
Well, that's true, although it sounds like it's going to be hotter in New York and New Jersey.
I saw that.
Yeah, it's going to be down here in South Florida.
You've got such an important job because so much relies when it comes to estate planning. And I was just telling you, I feel so bad because sometimes money changes family. And I'm sure you've been through some hellacious things.
Well, I have, and we all know that money has some very positive attributes.
Yeah.
And money, unfortunately, has some negative attributes. And when you talk about estate planning or a distribution plan or a financial blueprint in terms of trying to have an orderly and efficient distribution of your assets, you know, I get some people will say, "Well, I don't care. When I'm gone, let them do what they want."
Because it's later,
right? Let them do what they want.
Wow, that's not good. I can tell you that.
Well, it's not good. And
you must cringe when they say that.
I cringe, but I also don't believe them. People haven't worked a lifetime to create their assets to see it dissipated unnecessarily, and see it dissipated either because of poor management or because of a divorce or drugs or alcohol influence or any other unforeseen set of circumstances. And, you know, people don't give the credence to the time that's necessary to really develop a cohesive financial blueprint to ensure an orderly and efficient distribution of their assets. And that's the sad part. You know, and most people think, well, I can go online, I can get a will done, or I can get a revocable trust done. And by the way, and we've talked about it on some previous shows, you know, that's a very accurate statement. However, they don't get the noggin.
There's a reason why they're cheap.
Well, that could be, or maybe not cheap, just don't understand the implications of what can happen.
Everybody's different. I don't see how you can have one farm for everyone.
You can't, because every family's circumstances is completely different. And that's the key, and I'm glad you mentioned that. That's really the key to the process. It's the subjective information. It's not the necessarily legal document itself. It's how you create that legal document to conform with the wishes and the circumstances of that family unit that take precedence, that are the key to this process. And without understanding all of the potential pitfalls of what can happen after death, or what can happen even during your lifetime as it relates to your assets, people are missing golden opportunities.
One of the things I see your position is people don't plan long term. You've seen this before. This is what you do. You do estate planning. You prepare them. Well, wait a minute. What if this happens? Or what if this happens 20 years from now? I mean, you want to cut your kids out, or there's so many things that you think about that people don't even care about right now, but they should.
Well, that's true. And that's why doing this appropriately and properly and giving it some thought and giving it the time and energy that it requires is a key component to the process, because most people don't know or appreciate or understand or think about the laundry list of implications that might fall into place either during their lifetime with their family unit or even after death. Yeah, and I've said this before, a week doesn't go by, well, that's maybe an exaggeration, but certainly a month doesn't go by where somebody might say to me, Paul, I don't care what you need to do, but under no uncertain circumstances do I want that son of a gun daughter-in-law of mine or that son of a gun son-in-law of mine to get my assets. And that's and Steve, that's a legitimate concern.
It is.
That is a total legitimate concern.
But you think of things that can come up down the road that I wouldn't even think about. And that's what makes your position so important, is because it could be very costly to someone if they miss something, whereas you're not going to miss it.
Well, that's my job. My job is to look at the family circumstances, to look at the goals and objectives, to understand, some of the implications or some of the problems or some of the concerns that the family unit might have, and develop that cohesive financial blueprint. Estate planning is a misnomer. It's not estate planning. It's family planning. People think of estate planning purely from the standpoint of death. It's much more comprehensive than that. And I'd like to emphasize that to the audience, that this engagement is nothing more than, protecting and preserving your wealth. Most people are concerned, 99% of their time is predicated and focused on the accumulation of wealth. Give me 1% of your time. That's all I ask.
Right.
Give me an hour.
Right.
Give me a precious hour of your time, and I can show you, the issues and the concerns that you need to really consider.
I'm going to put you on the spot. Give me an example of someone who didn't plan properly that you saw, that you should have saw a lot sooner. They just didn't plan.
Steve, I can give you hundreds of examples, but one that we're going to chat about today. For example, if somebody doesn't have a will or doesn't have a revocable trust, to go through. If you don't have a will, and we've talked about this as well, as the state of Florida has already provided one for you.
Yes.
Okay, which probably does not conform with your wishes.
How much can they take out?
Well, it's not a question of how much they take out. It's really a function of how those assets are going to be distributed. Okay. Plus, there's time. Plus, there's energy. Plus, there's the legal fees involved with probate that most people want to avoid and can avoid.
Why would someone not do a will?
That's a great question, and the only answer I have.
Saw it was Prince.
Okay, with Prince,
didn't have a will. I mean, how does someone like that not have a will?
There are many, many famous people. I used to do some research, and the laundry list of famous people that have not properly planned, because we just don't know when that time is going to come. But going through probate unnecessarily is certainly a consideration.
Yes.
The distribution of those assets to people inappropriately is also a consideration. Most people think, okay, I'm going to die, I'm going to give my children the money outright. That sounds easy. And they can simply do that by avoiding probate, by going to the bank and setting up their accounts that say that at the time of their death, I want my beautiful daughter, Susan, or my
This is just a regular will.
This is not even a will. This is just simply in proper titling of assets, and have that account transferred automatically. But is that the most efficient way of doing it?
No, I can tell you right now, especially if you have a lot of assets.
Especially if you have a lot of assets, and even if you don't,
you don't want to leave that problem. Say you pass away, that is a major problem for all the relatives.
Well, it's not only a problem. Number one, the person who's receiving the money may not have the financial wherewithal to be able to understand and appreciate the management of it.
Right.
The individual that's receiving that money may have some marital problems. The individual who's receiving that money may have some special circumstances. Unfortunately, in today's society, drugs and alcohol seems to be, an ongoing issue, because it comes up in conversation many times in my office. They may not, have the understanding of what it means to manage a larger sum of money, whether it's $10,000 or whether it's $10 million. So there are strategies that can be implemented to ensure and protect that those assets are not dissipated due to
You think
divorce.
some people think they don't have enough money
I think lots of people think they
to
don't have.
not have a will?
I think lots of people
But
think
what
that way.
they think is not a lot.
And those
Could be
people,
a lot.
And not only that, but those people are the ones that end up spending more money in time and energy and legal expense because they don't have a will, it's not properly designed, or they have a revocable trust. You know, you hear a lot about revocable trust in Florida, and it's a great idea. And it's
Which
a great
we are
technique.
definitely going to talk about today. And it could really save you a lot of money from the way I understand it.
That's correct. It's a revocable trust is nothing more than just a technique to avoid probate. It also keeps things
Probate
private.
gets very expensive.
Probate can be expensive. It can be timely. Most people want to avoid probate. I think
Yes.
probate, the word itself has a negative connotation.
Well, my Renee has an uncle who passed away who did have a will, but there's someone now sticking their hand in there, and it's become part of probate now. And this happened a year and a half ago. So if they would have planned this properly, they wouldn't be going through this now.
Yeah, I don't know the facts and circumstances.
It's a year and a half later.
Yeah, but that's not an unusual set of circumstances.
And they're still paying.
Well, and the lawyers are getting fat and happy about it.
Exactly.
You know, and probate litigation is a wonderful component of the legal practice.
And there was an instrument they could have taken advantage of.
There was lots of things that could have possibly been done to avoid the unnecessary squabble. And what are they fighting about? Money.
Exactly.
You know, we talked about that earlier.
And don't think this cannot happen in your family.
Right.
And that's when we started the show. We were talking about money, what it does. You cannot take that attitude that, you know, we're a tight-knit family. It's amazing. I guess you see everything when it comes to money.
Well, I do. And, you know, and I also hear, oh, that'll never happen to my family.
Right.
Well, unfortunately,
What's it happens to?
when the matriarch and the patriarch of the family unit are no longer here, Steve, that's when the trouble begins. And that's when the infighting or the family fights come into play, and people are fighting over money, or they're fighting over assets, or they're fighting over jewelry, or they're fighting over an heirloom or a picture, or anything that, you know, may be important to that family unit. All of those things can easily be addressed.
Well, and I'm not involved in this, but I've told Renee, I said, why don't you just settle with this guy instead of, but it's not that easy either.
No, I mean, people have some unreasonable expectations
Yeah.
when it comes to litigation.
Hey, we're going to go to break. Paul, give everybody your phone number and your website address.
Sure, be glad to. I can be reached at 561-998-2362, and my web address is Boca Raton EstatePlanning.com.
And you'll be able to catch today's show on his website. He puts all of his shows up on his website. This is really a great attorney here. And you know what? If you know someone who's going through this, give them Paul's phone number. We're going to go to break, and we'll be right back.
The law office of Paul S. Labiner has been providing quality and cost-effective legal advice to professionals, businesses, individuals, and families throughout South Florida, New York, and New Jersey for over 3 decades. Their mission is to provide personalized service which ensures that you, your family, your business, or your assets are safe and protected. Call attorney Paul S. Labiner today, 561-998-2362, and let him begin the creation of a financial blueprint in conformity with your needs, desires, and concerns. It took much effort and hard work for you to enjoy all that you have today, so it only makes sense that you implement strategies to protect and defend it. The law office of Paul S. Labiner, PA, is a reputable law office nestled in beautiful Boca Raton, Florida, that is dedicated to providing you with personalized legal services that meet the specific needs of your family. Attorney Paul S. Labiner designs estate plans that ensure the most effective transfer of wealth, implement policies to mitigate income and estate taxes, and draft wills and trusts to maximize your family's wealth. Call attorney Paul S. Labiner today at 561-998-2362.
And we're back. We're here with attorney Paul Labiner. He's an estate planning attorney. Maybe we can call it elder law attorney. We can call him a probate attorney. He is one great attorney. And I got to say something before we go further. Your son practices law.
He does. I'm delighted to say that my son, Brandon, is an attorney, and he practices primarily personal injury law.
Okay.
Which is primarily, if you're involved in the
injury law,
whether it's a slip and fall or an auto crash or some other unfortunate set of circumstances.
Give out his number.
Certainly. You can actually reach him at 561-372-3800. And his name is Brandon Labiner. Keep it in the family. Absolutely.
Yeah. So we're talking about estate planning, and because we always have new people tuning in. You practice throughout South Florida.
That's correct.
How far north do you go?
It's usually up to Jupiter.
Okay. And how far south?
To Miami.
Okay. So it doesn't matter where you're located at. I want to get in today I hear revocable trust all the time. I hear attorneys advertising this. What is revocable trust?
Steve, it's a great question, and I wish I could just give a simple answer, but let me take a couple minutes to explain what the intrinsic benefits are of a revocable trust, what it does and what it doesn't do.
Is it good for everyone?
It's good for most people. Okay, it's good for most people because a revocable trust in lieu of a will is an opportunity to create the formal documentation necessary to have an orderly distribution of assets without the necessity of going through probate.
You have this instead of a will?
You do. In fact, what we call it in lieu of a will.
Okay.
It's your will.
Better than a will?
Well, it's in my view, most of the time it's better than a will. Yes.
Okay.
It's a will substitute, it's in lieu of a will, and it's a way of distributing the assets without the necessity of going through probate, which is costly, timely, and most people want to avoid that process.
So why doesn't everybody do this?
That's a great question, Steve.
I mean, just to avoid probate? I mean, that alone.
Well, and here in South Florida, most estate planning attorneys will advise their clients that a revocable trust in lieu of a will is the better mechanism of transferring wealth.
Okay.
And I agree with that general statement, by the way. So that's also my philosophy. However, and this is a big however, number one, there are lots of ways that assets transfer. So when we talk about a revocable trust, we talk about a legal document that in and of itself is ineffective. Okay? Ineffective. I want to emphasize that. Ineffective.
But it's ineffective.
Unless the assets are titled in the name of the trust.
Oh.
Okay, so what does that mean?
Well, it means you're going to better have everything tied down properly.
Well, that's true.
It's not going to work for you.
Exactly. And although many attorneys in South Florida advertise these relatively inexpensive revocable trusts, but that's only half the job. Unless those assets are properly titled, and we're talking about the bank accounts, we're talking about your CDs, your money market instruments, your business interests, okay?
So that's the first thing you've got to do.
Well, you have to draft a document in conformity with their wishes, and secondarily, make sure that those assets are properly titled in the name of that revocable trust. Otherwise, you've done absolutely nothing. You're going to end up going through probate. You paid the lawyer a lot of money unnecessarily, and although your assets will ultimately get distributed pursuant to your wishes, you haven't effectively addressed your master plan, because it's a master plan.
Right.
And the master plan is not only the legal documentation, but it's also to ensure that those assets are properly titled in the name of the revocable trust.
There's a lot of work involved.
Well, there is a lot of work involved, and I think maybe that's part of the aversion, is that it not only you have to pay me, and nobody wants to pay me. I know that. I appreciate it. I'm doing this almost 40 years, but you got to pay me, or you got to pay somebody's company.
So who would you say wouldn't be a good candidate for a revocable trust account?
I mean, if your situation, and I hate to use this word simple, because everybody thinks it's simple, How do I define simple? Well, I would define simple at least between a husband and wife. If you want all your assets to go to your surviving spouse, if you title all of those assets between a husband and wife, it passes automatically to that surviving spouse. It's called tenants by the entirety. Forget about the legal terminology. It does pass by operation of law. So you avoid probate, and yes, you accomplish your objective in terms of transferring everything to your surviving spouse. It's really upon the second death that really comes into play. So at the first death, it's really not too much of a problem. The second death, if there's children involved, or there's not children involved, if it's, if
spouse,
if there, even if there isn't a spouse or a domestic partner. I mean, today's day and age, we deal with domestic partners,
right,
that are legally spouses, and there may not be children that are legally surviving. Who is going to be the ultimate beneficiary? Is it going to be a charity? Is it going to be a charitable foundation? Again, this goes back to what we talked about earlier in terms of trying to develop that cohesive blueprint, to conform with your wishes. But getting back to what's simple, if there's just a husband and wife, that's simple. But if your assets are less than $100,000, I don't think you need a revocable trust.
Okay. See, that's what I was trying to find out.
Okay.
So basically, if your assets are under $100,000,
I would say if your assets are under $100,000, you probably do not need to go to the time and the expense of engaging the services of an attorney like myself to draft a revocable trust. You can properly address probate avoidance either through the way you properly address your bank accounts with rights of survivorship, or payable on death accounts, or if it's a retirement account.
What about no spouse passed away and there's no kids?
Then it depends on where you want that money to go to. Okay, if there's no kids and there's nieces or nephews and it's a small estate, you can set up your bank accounts at the bank or financial institution where at the time of your death, it gets distributed directly to that named beneficiary.
Okay.
Commonly referred to as TOD or POD accounts, which is nothing more than a payable on death account.
But you like revocable trust.
I do like revocable trust.
Okay.
I do like revocable trust because it simplifies the process. It's orderly. It's efficient. It's timely. It's private. So privacy is a big issue for many people. It allows for a much more efficient way of dealing with the distribution of assets. And again, the issue becomes, is everything properly titled in the name of that revocable trust?
For peace of mind,
Okay.
tomorrow afternoon, I want you to call Paul. Let him tell you. Maybe you didn't think about a revocable trust. Let him sit down with you, because I'm going to tell you something. One of the things you're going to learn from this show is, wow, I didn't even know about that. And the worst thing is to keep sitting on it as time goes by. I love what you do. Give everybody your phone number.
Be glad to. Again, I can be conveniently reached at 561-998-2362.
And give everybody your website. Again, you can watch the shows on there, the playback the shows on there. Give everybody your website.
It's Boca Raton EstatePlanning.com.
So important what you do. And Paul will be back with us next month with more Ask the Experts. Thanks for tuning in today. Tune in again next week at 3 o'clock on 740 a.m. and at 5 o'clock on 1470 a.m. We'll see you next week.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.